Good afternoon and welcome to the Saturday edition of the People Show right here with Mark Wallace, your host and facilitator, here with you. And of course, on Saturday afternoon, we always have our legal hour. And who's going to be joining me soon will be none other than the supervising judge of the Cook County Circuit Court, Judge Leonard Murray, who's the supervising judge over the administrative review as well as over housing. So we're going to be talking about great topic today. Besides taking all of your legal questions that you may have, and of course, any legal questions that you have, you can type them into the chat, into the comment chat, whatever your legal question is. I will read it off to the judge, and the judge will address your legal question. Now, the judge cannot give you legal advice about your specific case, but you can certainly ask questions that may be similar, and he can give you an answer as to what the law is related to that particular subject and what the court process is. So we'll be talking with that about those issues with the judge coming up in just a few minutes. But before he comes on, I want to talk about something that I continue to hear about, and it's sometimes disconcerting, but it is also revealing to me. It's revealing to me because it lets me know what is some people's aptitude, who either they pretend that they don't know or they pretended they know. And they make all these comments depending upon what particular party is in power at the particular time. Like President Joe Biden is a Democrat. Democrats are in charge of the White House. The Democrats control the Senate. Now, Republicans are completely out of control, completely disorganized, and don't particularly have a core. But people start talking about things like Joe Biden's out of control spending. It's not spending, it's investing. The bills or the spends or the appropriations are investments that the country and we as citizens will get a return from. When you put somebody to work, that person is a taxpayer, becomes a taxpayer. Not only do they become a taxpayer, but they become a job creator because they're buying goods and services. And because they're buying goods and services, someone has to supply those goods and services, and someone has to make those goods and services. And as a result of someone needing to make it, they need people to make it, they need people to produce it, they need people to box it, they need people to ship it, and they also need people to market it and sell it. So when you start talking about spending, you're really talking about investing. So all this talk, only when Democrats are in trouble is it called spending, or in charge is it called spending. When the Republicans are in charge, it's called tax cuts, which you and I have to pay. It is a spend that is being given to the wealthiest among us. So, I just wanted to address that briefly this morning. I'll be talking more about it on Monday night, on the Monday night edition of the People Show. And we're going to be talking more about the policies that are coming out of this administration and that have come out of this administration with the investments that are being made in infrastructure and being made in the lives of people, which is also a part of infrastructure. So we're going to be talking about that on Monday night's edition of the People Show. So just make sure that you tune in for our program every Monday night. at 7 o'clock right here on Instagram, YouTube, Facebook, X formerly known as Twitter. And of course, we are featured and sponsored on intellectualradio.com every Monday night. All right, so let's get right into it. I see that Judge Murray is there in the waiting room, so we're going to bring him right on board with us. Judge Murray, how you doing?
Good, Mark. How are you? Good afternoon.
I'm doing just great. So we talked about this, and we had been discussing the administrative review, and there were a few items that we did not get a chance to get to on our program last week. And so before we get into this week's topic of talking about demolition in the buildings area, and certainly what that process looks like, wanted to go back and recap and go over any items that we didn't discuss that you wanted to cover this week as it relates to the administrative review.
Okay. Well, I think it's important for the community to understand what happens when a vehicle is impounded. And the city has, under the municipal code, a number of circumstances during which they can impound your vehicle. Now, also, it's important for us to know that uh, the city code, as relates to vehicle operations, is a strict liability ordinance. So it does not matter that you, as the owner, isn't operating the vehicle. Uh, in effect, the liability is derivative. So whoever has your car, that liability is derivative to you. So you are responsible whether you're behind the wheel or not. So there are a number of folks who I'm sure have encountered maybe a red light ticket or speeding ticket. So it doesn't matter that you were not the operator, because it's deemed that you were the operator and you're liable under the city ordinance. And the distinction here is that you may remember once upon a time, if a person who was cited while operating a vehicle was given a ticket, and the accumulation of those tickets could impact your license, the status of your license. Well, the city ordinance takes away the question of whether or not the violation impacts your license. What it does is it imposes a fine on you, uh, derivatively from the person who you allowed authorization to use your vehicle. Now, so what that means, just an example that I have seen from time to time, is that you loan your car to one of your children, and for some reason they put behind the wheel or allowed to get behind the wheel a friend of theirs. So that friend is operating the vehicle through the direction, or at least the authority of your child, from derivative from you. So if there's a violation that occurs while that friend of your child is operating, then that violation is yours. You're responsible. Now, the only circumstance would be if you would claim that it was a theft. And of course, in the example that I gave, that could not be alleged because you had given permission to a child who then gave a permission to a friend. That would not constitute theft. Now, of course, if in fact your vehicle was stolen and you initiated a report uh, uh, during the timeline when the event occurred, then that would be a defense. But of course, timely uh, complaint to the authorities of the theft would be important to bolster your credibility in that regard. Um, so that's an important factor, and it's something that from time to time I've seen where the owner of the vehicle comes in and suggests, "Well, I wasn't operating the vehicle, um, so therefore I should not be liable." Well, sorry, but you are. If you gave authority to uh, 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 someone to operate your vehicle, that they encountered some sort of violation from operating their vehicle, then you're responsible. Now, where this becomes really critical is under those circumstances where, under the city code, uh, there's a stop made and things occur, uh, which would allow the police authority to impound your vehicle based on that set of facts. So, uh, common occurrence, or I shouldn't say common, but frequent occurrence, is where someone is operating a vehicle who has either a suspended or revoked license. If that occurs, the city has the right to impound your vehicle, uh, meaning take it off the street, tow it off the street to one of their lots, and then they're required to give you notice so you have the opportunity to contest the impound. And ultimately, um, there is a fine associated with that infraction. I can't tell you the exact amount at this point, but they can be fairly steep. And by that, I mean in the thousands of dollars. Um, so, and it's important to be aware of the process involved here. So, if your vehicle is not returned when you have loaned it out, you need to have a very serious conversation with the person who you did loan it to and was operating it at the time of the police stop as to what occurred. Because you got some diligence required on your part in order to protect your position. So it's very critical because there's situations where the use of your vehicle is your means of income, getting to work or some other enterprise that you may be involved in. So to have to do without that vehicle, even for limited periods of time, is very significant. Now, there are situations where you can uh, post a certain amount in order to have access to it, but it doesn't take away what could be the ultimate fine. So this process is critical. Uh, Now, let's take this a step further. So let's assume that a person behind the wheel at the time of the stop cannot produce a license, either doesn't have one or it's been suspended or revoked, uh, and therefore the vehicle can be impounded. There is a significant fine imposed in that circumstance. Um, uh, And sometimes there's a criminal charge that's associated with that stop. Now, what happens apparently in the environment that we're in, there's certain sort of offenses, such as they call them 6303s, driving while suspended or revoked. This is under state law. Um, that the prosecutor's office declines to prosecute. So they will nully prosecute the case, meaning they will not go forward. That may not be a defense to the charge, which would then uh, suggest that the stop may have been bad, and therefore there should be no fine imposed in connection with that occurrence. The problem is that a nulli pros is not a not guilty, or it is not a situation where the charge is dismissed ultimately based on a Fourth Amendment violation, where there's been some other set of facts that will quash and suppress the evidence that is recovered as a part of that stop. For example, if there's a stop and a weapon is recovered that's not registered, or if contraband is recovered, drugs are recovered. Uh, uh, then unless those charges are result of a trial itself or a motion that suggests that the police activity associated with that occurrence was illegal or unconstitutional, then that may not uh, um, support a claim that there should have been no impound of the vehicle, or that there should be no fine imposed. So it's not necessarily the case that where the state decides to nully price charges, and ultimately whether to prosecute or not uh, is within the discretion of the state attorney's office. So if they decline prosecution, that does not necessarily mean there was no violation. It just means that they didn't pursue the criminal charge. That is not necessarily a defense to the civil process of the impoundment. The fines imposed in that circumstance are not criminal, they're civil. So it's vital that folks understand the difference. Very often I have these cases, and uh, the respondent in the administrative tribunal gets a finding of liable, uh, even though the criminal case is disposed of favorably to whoever was involved in the transaction. That may not make the part of the occurrence go away that resulted in the impounding of your vehicle and in the fines imposed in connection with that. So that's very critical knowledge that the community must have, because I can't tell you how often I'm encountered with that, where the criminal prosecution somehow goes away, other than the result of a trial with a not guilty or a motion to quash arrest suppress evidence that is granted. Um, it may just be that the state doesn't believe they can meet their burden of proof at trial, and they will nully prosecute the case. That is not the same as a not guilty or situation where there's an alleged constitutional violation related to search and seizure.
Well, going back to the impounding, because there's a lot of um, questions about that, because the impounds used to be operated by the city, but some impounds are private. I'm not sure if all of them have been privatized, but I have gotten reports from people that their car was impounded. They went to go get their car to pay whatever the fees that they needed to pay, but they were told that they could not get their vehicle for a certain period of time, but by the impound lot. But the impound lot still charges those daily storage charge that continue to accrue. And I've heard some people say that their car has only been there for a few days and they have cost upwards of more than $1,000. Is that regulated as to what the impound can charge?
Well, it's my understanding. Again, this is a City of Chicago ordinance, but it's my understanding that there is a charge for the removal of the vehicle, or the tow charge, and in addition, there's a daily storage fee. And as I recall, it changes at a certain period of time, and I can't tell you at this moment exactly when that change occurs. Um, but it decreases after you've reached a certain number of days with your car being situated in an impound lot. But in any event, the problem is at that level, uh, uh, you're going to have some difficulty arguing, if you will, uh, with the powers that be, that what they're charging is inappropriate, um, and therefore you should release it based on a certain number. Um, uh, the problem is they're not going to do it because they believe the calculation that they come up with is the right number, and that's the number which you should tender in order to retrieve your vehicle. Um, you then have to uh, continue to process and protest the amount. that you ultimately pay to release the vehicle. But of course, that's going to take some litigation of some sort, either at the administrative level or, in fact, in the court, to challenge and have reduced what you paid. But there's a cost to doing that. So you must factor in when you decide to contest what the claims are by the impound lot. And it is true, I believe, that not all the lots are operated by the city of Chicago itself. They have contracted out that effort. Um, Even though I think in most instances, the location of the lot itself is city property, it is not private property. So you would think that the fact that it is operated on city-owned land, not privately owned land, that they should be functioning exactly consistent with what the city ordinance requires. And it seems that in some instances they may not be.
Yeah, very true that there needs to be one set of rules for everybody to contend with. And apparently there were some questions on whether or not that is happening at the impound level. The charges, so you mentioned that someone could come into the administrative review and they could motion it to contest the amount that was charged to them by the impound lot. If they prevail, how do they collect the funds? Does the court give them an order that the impound lot has to return whatever that dollar amount is, if found to be the case?
Well, we would order the city to refund the improper charge, since that lot is operating as an agent of the city uh,
Okay.
under whatever contractual arrangement exists.
But the
But
liability would fall on the city
yes, because
because
it's the city
they're merely an
charges
agent.
that are being imposed on the owner of the vehicle, not the lot's private charge, if you will, for storing the vehicle.
And how long does the impound lot have to, um, or are they required to hold on to a vehicle? Because again, I'm hearing that people are trying to retrieve their vehicles and they're being told that your automobile is going to be auctioned off um, at a certain period of time, and then they would not be allowed to get their vehicle. So what's the requirement? Is there a requirement that the impound lot has to maintain that vehicle, or certainly secure that vehicle for a certain period of time?
Uh, so the city code requires that not only with respect to impounded vehicles, but any contest of a fine imposed by the city, that the collection effort and or the protection of the property itself is 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 uh, is halted until such time as the case is resolved. Now, one thing that I tell people is that even though the state statute, there is a state statute that governs administrative review. It is not city code, so that's important to know.
Mhm.
And the state statute on administrative review says that you must initiate that case for review within 35 days of the entry of the order. Now, it gets tricky here because not in every instance is that order uh, distributed on the occasion when you are there for hearing. Sometimes it may come out later. So, as I understand it, it's deemed served uh, 3 days after mailing. So if you're not handed that order on the date your hearing concludes, then it's important that you stay on top of when that order is issued. Now, more importantly, it is not necessary to wait 35 days to initiate the case. You can initiate that case as soon as that order is entered. That day, as soon as the case concludes, you can find your way to the nearest courthouse that has jurisdiction over administrative review in your circumstance. And I want to elaborate on that point in a bit. But uh, by filing that action, it should stay any adverse consequence to what would occur. Uh, and let me elaborate. The point of elaboration is that I had a case a couple of days ago that was filed by a person, and the ticket was issued by the village of Berwyn. Well, certainly Chicago has the largest administrative hearing process that there is in the state. Um, but that case that involves a ticket issued by Berwyn is not one that you would file in the Daly Center, or at least a circuit court in the First Municipal District, which essentially is the city of Chicago. You would have to file that case in the district uh, that hears matters related to citations from the city of Berwyn. In this instance, that happens to be the Maywood Courthouse. So that case, and the case was a traffic matter, some sort of traffic violation. We don't really know exactly what it is because we will never get the citation since the case should not have been filed in the Daily Center. Uh, so you also have to be mindful of where the case should be filed. Now, as long as it's filed within the 35-day period, even if you make a mistake in terms of where you file it, you're protected. It's just that the case will just have to be transferred to the proper district. But as long as you get it filed within their 35 days, you're protected in terms of the statute of limitations. So you do not have to wait 35 days to file the case. In fact, you should file it right away so that you can protect yourself. Now, uh, I also encounter situations where you mentioned it in your lead up, where something happens to the vehicle after impound. Uh, well, if you make a mistake in terms of delaying and filing the case, the city does have a policy, city of Chicago at least, does have a policy relative to how long uh, it will take no adverse action towards a vehicle that's in their possession. And adverse action can either be selling it in an auction or destroying it. So it just depends on, I don't know who makes that decision, but that is possible. Um, But again, if you have not filed that case quickly, then you run the risk of one of those adverse actions if it does not occur, or the city is not mindful of it, or at least given notice of it, uh, in order to prevent them from taking any action, adverse action towards your property. Now, what I customarily do when I'm aware of the fact that the vehicle's impounded, uh, I do a couple things. First, I make the city respond more quickly to that case than other types of administrative review matters because of as I mentioned, the importance of folks having access to their vehicles. Need it for work, could need it for other enterprises, or even, how do I take my kids to school in the morning without a car? Uh, uh, the other thing is, and I dropped that point. Uh, the time that it takes for the record to be prepared, rather than the 60-day, which is typical answer period for administrative review. Uh, I shorten that to 30 days. I also, as part of that intake order, that initial order in court, I require that the city take no action against that vehicle while the case pends until it's resolved. And I include that specific language in the order so that, if that order is violated, then the city runs the risk of being held in contempt for violating a court order. Those are steps I take because I want to make sure that when the case concludes and while it pends at least, the vehicle is protected and the city's aware that it must take protective action against the vehicle.
Well, it certainly looks, though, that you are taking a real close look at making sure that the process is fair and balanced. And so by you making sure that if someone files a case, obviously they have to file in order to get those protections. But if someone files a case, then whatever charges there were, those charges, until it's been fully determined on the liability, or if there was liability and how much that liability was, that clock stops until that time determines. But that can only happen when somebody files a case and gets it before you so that you can make that determination.
Yeah, exactly. And also, to go back for a moment, allegation of a criminal violation, I will also request that the transcripts from the proceedings where the case was disposed of are made available so we can see exactly how it was disposed of. And there's just a lack of understanding that where the states nully prosecute, it's a Latin term, a case, that is not an adjudication on the merits. That's a decision to decline prosecution. That does not suggest that you were not guilty, which is a whole different outcome in criminal litigation. So it's important that it's understood that even avoid criminal prosecution, you may still be subject to the civil process relative to the imposition of a fine for whatever the alleged violation is. In fact, there is an Illinois appellate case that says that even if you are absolved of the criminal violation, you could still be liable for the criminal violation. Now, I have a hard time understanding that logic, but it is embedded in Illinois law.
So you could have some civil exposure and not necessarily criminal exposure.
Yeah, exactly. And there's a misunderstanding out there about what it means when the state declines prosecution. It does not mean you're not guilty. Okay, I can't say that enough. The state declining to prosecute a case does not mean you're not guilty. It means that for whatever reason, the hazards of litigation are viewed. Who would the witnesses be? Are viewed. In fact, Mark, you may be aware that I think Kim Fox's office had created a list of police officers not to use as witnesses in criminal matters. You are aware of that, right?
I'm aware
So
of that,
then
yes.
if the circumstances of your situation of one where the officer or officers involved in your occurrence are on that list, then the state may well decline prosecution. Okay? But
Yes.
that does not mean you're not guilty. It just means they're declining prosecution. So in an impound situation where the underlying allegation is one of a criminal context, then the decision to decline prosecution for whatever reason, state does not have to tell you why they're declining prosecution. That's not, they don't have to put that on the record, if you will.
Right.
They can just nully prosecute. Uh, that does not mean you're not exposed to civil liability for the violation of the city code. The burden of proof is less for civil than criminal. Um, and as I mentioned, that there is that state appellate court opinion that suggests that even if you are found not liable or not, I'm sorry, not guilty, I'm going to use the right words.
Mhm.
In a criminal context, that does not mean that that is a defense to the civil process. Now, one of the things that troubles me about that is, for example, uh, if you file a motion to quash, arrest, suppress evidence in a criminal case, and if that motion is granted, then that suggests that there's been a constitutional violation, I think. So if there is a constitutional violation, then that would be a finding by a sister court, if you will. Uh, should the citing authority, in this case the city of Chicago, be rewarded for uh, unconstitutional conduct? I think that's a question that's hard to get beyond. If there is an order that says, the motion to quash, arrest, suppress evidence is granted, uh, that suggests a constitutional violation. So
And would that be a violation on behalf of the respondent or on the city?
that would be a violation by a city agent. It's
Right.
one of its police officers. So should the city then be able to go forward on the civil violation, given the fact that they've been adjudicated as the basis for that civil action is unconstitutional conduct?
So I get that if you're not criminally found guilty, doesn't mean that it doesn't eliminate your liability, because the bar is different.
We're not guilty, but not prosecuted.
Not prosecuted,
Right.
right? Doesn't mean that you're not liable for it or that you're not guilty.
Right, exactly. Yeah, because if you're not guilty, then that would suggest that there's no basis for the civil violation. If you're not guilty,
Right.
you could argue that the burden of proof is different for
Right. There's a
or
lower
else.
burden of proof for civil. It's just the preponderance of the evidence, as opposed to on the criminal side that it has to be beyond a reasonable doubt
Right.
uh, at the criminal level. And so, as you say, the burden of proof is much less. And one of the most famous cases that we know of is the O.J. Simpson case, where he was found not guilty of the charges that he was charged with, but later in a civil case, he was found to be responsible.
Yes. Yep. Yeah. Probably most recent famous example, and of course, resurrected again because of his death over the last couple weeks or so.
Right. Right. Well, and that was also a question that was raised. I don't know if we talked about it. I don't remember. I know that I asked you about it, that his pension, even in that case, his pension was protected, and he, may have had some, I guess, was able to shelter some other assets from being um, uh, attached or them going after that. I think that in the last report that I read, they had only collected somewhere around $130,000 of a $30 million judgment that is ballooned to, I think it's some $54 million because of the accrued interest. It could be more than that. So the fact that he has now passed, is there, and I'm asking this, I know that you've answered this question before. The fact that he has passed, is there any way that his assets any of his assets can be protected now that he has passed because of his heirs? Or can the um, can the plaintiffs in that case, can they go after whatever his estate earns in his death? Can they go after every penny of any monies that's derived by his estate? Because I don't think that someone else can act as a proxy on his behalf. It has to come through his estate first.
So, is part of the reason why he moved from California to Florida is because Florida offers greater protections from creditors than California does.
Mm-hmm.
So that's the folks didn't know that was the reason, justification for his leaving California, which I think is where he was born, if I'm not mistaken, and then moving to, and I may be wrong on that, but because I know OJ actually went to a junior college before he went to USC for football. Um, so I'm trying to think of now if California is in fact his home state or if it's one of the other 49 states. But in any event, he left California, which is where he made his fame and fortune, and moved to Florida to take advantage of the greater protection that state offered at the time for debtors than California did. Now, and as you suggested, of that multi-million-dollar judgment, less than $200,000 of it was collected before he died. Now, once his death occurred, then I think all of those assets should be exposed to creditors because I don't think he has any minor children at this point. They're all adults. And at the same time, I don't know, I'm citing this not knowing what the answer is, but I think part of the recipients, the beneficiaries of that judgment were his children, who were minors at the time of the event that occurred that led to the multi-million-dollar judgment being entered. I think their grandparents brought the action on their behalf.
Yes.
So they are the beneficiaries of that judgment, but they would be his heirs anyway, sharing along with his other children, who would be his heirs. But of course, that judgment would come off the top.
Mm-hmm.
So they may in fact wipe out the estate by virtue of enforcing the judgment that they benefit from, um, as brought by their grandparents.
Right. So, and we're talking about the Ron Goldman's families, um, and that would be his children.
No, now I thought there was an action by Ron Goldman's parents, but also the grandparents of OJ's minor children. I thought they brought an action as well.
They brought an action also against OJ on behalf of Nicole's children, minor
Yes,
children at the time.
right. So
Right.
as claimants, all of them uh, would be entitled to go after whatever assets are there. And since those then minor children are now adult children, I don't think they would have any preference over Ron Brown's family to collect on that debt as well. Uh, uh, and these are some things that probate lawyers probably could opine on, but they may be essentially sharing that estate. And I don't really recall if it's been suggested what the nature of OJ's estate is.
Right.
So it may well be that those two judgment creditors, to the extent that there aren't any others, would share the estate. I doubt that. I doubt that he was worth $30 million at the time of his death. I don't think he was. Um, so they're probably going to share it with whatever those assets would be at this point.
Right. Well, that is going to be very interesting because I had not thought about the action being taken by Nicole Simpson's parents on behalf of the grandchildren who would be heirs to whatever the estate is. So, but the heirship, I guess the question becomes, does the heirship take priority over the judgment, or does the judgment take priority over the heirship?
I think since they are not minor kids, I think the judgments take priority over the heirship, because they're minors involved. Now, if there were minor children involved, I think that equation may be flipped on its head, and that the public policy would be to make sure that the minors are provided for even before creditors.
Okay. All right. Let's jump to what our main subject was to discuss today is building demolition court, and what that process is. Now, there are buildings, and what constitute a building being designated to be demolished, and how long does that take? Now, we see these big signs that are put on these buildings around the city that are vacant or unsecured. And a lot of people contend that that X means that that building is a building that is marked for what they call fast track demolition. Can you clarify what that process is?
Okay, well, first of all, the X that is sometimes posted on a structure essentially is a disclosure that the utilities have been shut off. By that, I'm talking about gas and electric, and likely water. And that's a safe harbor, if you will, for first responders to know that they're entering a structure that doesn't have possibility, or at least I shouldn't say that, because anything can happen, but where the gas supply has been shut off purportedly, as well as the electrical, so that those hazards aren't present. Now, unless the property has deteriorated to such a condition that it is at least 30% deteriorated, it does not customarily begin as a case filed by the city in a demolition court. And in our section, at least in cases that are heard in my section emanating from the city of Chicago, normally cases start out in what's called conservation, essentially meaning that the conditions are not dangerous and hazardous, and steps can be taken to remediate the conditions that do exist. And is not, the term is used, phrase is used, demo worthy. Now, over time, and the condition of the property could be one that is in fact vacant. It could be unsecure, but its physical condition is not one, at the moment at least, that would be worthy of being demolished. So over time, though, if that condition is not ameliorated. No one is stepping forward to undertake rehab of the property or control it, preserve it in some fashion. Then it could evolve to being transferred to one of the two demolition rooms that exist in our section. Um, but for the most part, most cases do not start out in demolition, one of the demolition courtrooms. That's unusual that would occur. Uh, so it's a gradual decline, if you will, and sometimes it's rapid. But in any event, it's not typically the case that the property starts out as one um, where demolition is sought. Now, of course, there can be intervening factors. Um, Vacant property tends to be one that is targeted by folks who are without homes. Um, uh, the basic human instinct is survival. So, Chicago can have very harsh winters, and in order to protect yourself, uh, many folks will find abandoned structures, enter them, try to keep themselves warm, which normally means starting a fire, one that gets out of control, and therefore it can very quickly evolve to a situation where a property that was not demo worthy now is demo worthy because of the destruction of its inner um, system by virtue of the fire. So in that case, that would be a case where situation where the case would be filed as for demolition because what remains is so severely gone that the cost to rehab it would be pretty significant and maybe not economically feasible. Um, so if that happens, then uh, the city has a burden of proof to prove up um, the conditions that warrant their request for demolition. They usually do the testimony of an inspector and also the use of photographs. Um, and they try to convince the court that this property is worthy of demolition. Now, assuming a demo order is entered, it's the city's right to execute that order. It's not something that the court is involved in terms of causing a property to be demolished itself. We don't have those resources. And to some extent, it's fairly expensive to demolish a structure. And I can just tell you that the city has any number of orders where they are authorized to demolish a structure, but don't have the budget. It is quite expensive in order to demolish a structure. Uh, and how they go about doing it also is not anything that the court is involved in. Uh, there is a permit that they issue to a demolition company in order to undertake the task. But again, that's an administrative process. It is not one that the court is involved in. Also, there is this notion of the police power of the state. I'm sorry, in the city. And what we mean by that, or at least what that term means, is uh, the, the local government uh, uh, takes on the aura of being a parent. So in order to protect its child, if you will, which is the health and safety of the city of Chicago, they can exercise the authority to go ahead and do certain things even without a court order. So there are administrative orders that the city initiates across the universe of its various departments, where it deems that it is such a situation or consequence that we must take action without uh, without the protective blanket of a court order. And it's done fairly frequently, where the city will exercise its police power in order to take certain acts, and in some cases, it is demolition of a property. Now,
So
on the other hand, I'm sorry, Mark, go ahead with your question.
no, so there in the instances where the city um, takes what would I guess consider to be an emergency action because the threat of harm or safety is um, pretty extreme or immediate, the city feels like it needs to take appropriate to neutralize whatever that safety hazard is at that point. But does the city have requirements by the court that they have to file reports with the court
No,
to substantiate the actions?
nope. It's an administrative action that they take based on their infinite judgment. The court is not involved in that case. Early on, I had a situation where the city came in on in a matter where they were seeking a demolition order, but they had not bothered to serve anyone in connection with the case. No notice whatsoever. And I didn't allow it because I think if you're going to file a case in court, the basic principle of our jurisprudence is that you give notice. You give notice to the person with the affected interest so that they have a chance to come in and defend it or object to it. Uh, but in this situation, and this is a number of years ago now, but the city uh, filed an action, came in, uh, not really citing what the emergency was, at least in my mind, uh, and asking for a demolition order without any outreach at all to whoever the property owner was. And I didn't allow it because I said, at least you need to make an attempt to give notice to who might be affected by this. If you believe it is of such an urgency, certainly you could have taken the steps to do it. They've got the ability to send folks out, including members of the police department to serve papers and so forth. So it was inexcusable to me that they would not make some attempt to give notice to the affected parties in this situation. So I didn't allow it. And I told them, I said, if you conclude that it is that of such a serious nature, then you got the ability to do it without a court order. And frankly, I don't know what they did ultimately with the case because they never brought it back.
You probably gave them some information that they were not aware of. And they may have. So, but I get it. It certainly makes sense that if there's a property that is in serious disrepair, and for any number of reasons, I can understand the city having the administrative authority to take whatever actions necessary to bring that safety hazard to under control.
Yeah, and another example of the exercise of police powers is what happened during the COVID era, where folks were taking advantage of the situation and looting stores and doing creating all sorts of havoc around the city, and downtown area was targeted. Um, so the city, in its infinite wisdom, would close off certain streets and areas that they felt were targeted. So that's another example of the city exercising its police powers in order to protect the public good.
Yeah. All right. Well, listen, we are up against the clock, and we're going to be losing our feed here. So we're talking with Cook County Circuit Court Judge Leonard Murray. This is the Saturday edition of the People Show's Legal Hour, and we're going to continue this conversation next week, Judge Murray, that we get more into, because we certainly got started in it late because we needed to clear up the questions on the administrative review process. But we're going to continue our conversation next week, folks, so that you can get the full information about what happens in that whole demolition process. And any questions that you have, certainly type them into the text, and the judge will get the questions, and we will address them on next Saturday's edition of the People Show. So we want to certainly thank you, Judge Murray, for being with us again this week, and to thank all of you all for participating in our weekly program of the People Show. Thank you so much.
All right. Thank you, Mark.
All right. Thanks, Judge.